Time.
I propose sharing my time with Deputy Sherlock and Deputy O'Snothy.
Please. You might just wait about 10 seconds, Deputy, and we get you some order. But without interruption.
That's the kind of solidarity I appreciate. Cathaoirleach, thank you very much. Cathaoirleach, I asked the House to give a second reading to the committees of the Houses of the Oireachtas Powers of Inquiry Bill 2010, which has been published in my name on behalf of the Labour Party. This bill seeks to restore inquiry by parliamentary committee. The Labour Party believes that institutional reform, wider than Dáil reform, is necessary, but that must wait another day. The Labour Party believes that a parliamentary power of inquiry is a necessary and intrinsic to the proper functioning of a representative, responsible parliamentary democracy. We believe that our state is the poorer and has functioned more poorly in the absence of a system where those who exercise authority in our state can be called to account for their performance in office. The bill goes one step towards meeting the criticism of the effectiveness of our national parliament. And as I say that, I am aware that there will be a test arising in this House concerning accountability very shortly. I just heard a pathetically self-exculpatory statement from the Minister for Defence, who tells us that he acted innocently, having crawled around Limerick, spreading disgraceful rumours about a rival candidate running a brothel. And he has the cheek to tell us he forgot it. And he has the cheek to come into this House and say that it was an innocent misrepresentation. Now, I hope that when this House is given the opportunity on the motion of no confidence, that Minister Gormley will revert to his formerly high moral stance. He'll have the opportunity with the Greens to vote on this motion of no confidence, and we'll see whether this national parliament is capable of asserting accountability. The powers conferred by the bill, Las Cancolia, will enhance the relevance of Dáil Éireann. It will help distinguish Parliament from government and demonstrate the capacity of Parliament not only to hold government to account, but to seek and get answers on matters of concern to our citizens. It's very damaging to confidence in politics that the perception is abroad that deputies who are not office holders are without influence and are used merely as lobby fodder to rubber stamp measures brought forward by government. As the economic crisis has deepened, so the criticism of Parliament and the practice of politics has grown. Yet the financial and banking crisis has exposed in a dramatic way that when the economic crisis threatens the collapse of economies, the last resort is the state. The nature of state intervention may well be the subject of political dispute, but ultimately we rely on governments to lead the reconstruction. Politics does matter, and public debate in Ireland at the moment is being steered towards the conclusion that we're in the mess we're in because of inherent failings in the political system. This is a convenient and self-serving conclusion for the party that has dominated government for the past dozen years. We're in the mess we're in because of traceable actions by successive governments led by Fianna Fáil and inspired by the neoliberal politics of the PDs. The functioning of the political system is far from perfect, and it is in need of constant reform. But the political system is not responsible for the reckless decision-making that has resulted in the Irish recession being worse than is being experienced throughout most of Europe. Dáil reform is the mantra of the day. Critics inside and outside Parliament each have their own particular aspect of Dáil reform to which they would give priority. Others don't know what they mean by Dáil reform, but it's a useful weapon to denigrate the political process. Oppositions, it must be agreed, are generally enthusiastic about radical reform, only to see their ardour abate somewhat when they become the government. Governments work hard to ensure that they're not exposed to any greater degree of accountability that they can get away with. And some governments, like this one, resist reform as a principle of ideological conviction. It is that power to inquire into public administration that is the focus of this Labour Party bill. I expect that the government will not obstruct it going into committee, now that the threat of a public inquiry into the banking crisis no longer hangs over the head of the government or indeed over the bankers. I regret very much, and this House will come to rue the day, that we decided not to have an open, accessible public inquiry into the banking disaster. But that's not an argument for failing to address the defect identified by the Supreme Court in legislation governing the powers of the Dáil and Seanad through their committees to conduct inquiries into matters of public concern. Lest there be any doubt, I want to acknowledge that members of the House cannot and should not substitute for the normal process of the rule of law. We're not prosecutors, we are not judges, and we are not juries. But we are legislators. Our job is to frame the laws by which this state is governed. We cannot do this in the abstract, as if we were blindfolded or as if we knew nothing about the situation in the country. We must make laws on an informed basis, and we must know how the laws we make are applied in practice. At the moment, these houses do make laws on occasion that are not enforced, or are capable of being ignored, or that are in practice routinely ignored. And that's why the Dáil and the Seanad, two houses of our national legislature, must have the power and indeed the duty to acquire and consider information as to how the laws we make are administered on a day-to-day basis. The Dáil, of course, has additional duties. It is the Dáil, under our constitution, that elects our government, and it is to the Dáil that our government is responsible and accountable. It is the Dáil that must approve every government proposal to raise revenue, and the Dáil must approve every proposal to spend revenue. And the Dáil has the job of scrutinising the accounts as to how and how well every item of public revenue was spent. All of these are reasons why, especially the Dáil, must have powers to inquire into public administration, into how well the laws we pass work in practice, how well they are administered, what defects are obvious in our laws, what new laws we pass in order to change rules that do not work, or bring in new rules where no proper rule applied before. All of these are self-evidently compelling arguments for why this House should have the power to inquire into matters of public concern. Regrettably, the collapse of the Abbey Lara inquiry has been treated as an excuse to collapse inquiry by parliamentary committee. This has suited governments since 2002, whose propaganda machines have put abroad the insinuation that arising from the Supreme Court decision in Abbey Lara, inquiry by parliamentary committee is no longer feasible. Any fair analysis of the judgments given by the Supreme Court in Abbey Lara would show that this was never intended to be the case. For example, Mr. Justice Hardiman made plain that it was not the intention of the Supreme Court to attack the established practices of the Oireachtas when he clarified the scope of the challenge in Abbey Lara as follows, and I quote him: "There is nothing in the Constitution which would prohibit a committee of virtually any kind from conducting an inquiry into a matter which it considered worth inquiring into, to adjudicate, in the sense that the term is used here, on the culpability of citizens in their conduct, in my view, be equated with the everyday search for knowledge of facts or expert opinions." Mr. Justice Geoghegan, in his judgment, acknowledged, and I quote him, "A legitimate inquiry by a committee of the Oireachtas, which was directed towards a perfectly proper legislative purpose, might in some circumstances inevitably and unavoidably lead to implied blame being attached to an individual. That would not necessarily render the inquiry ultra vires. It is also true that a legitimate Oireachtas investigation may inevitably result in a finding of fault in a management system, which in some circumstances could involve an implied attachment of blame. That also might be legitimate." The Chief Justice, Mr. Justice Murray, said, and I quote him, "I do not see any reason why the Oireachtas cannot conduct inquiries of the nature which they have, for practical purposes traditionally done, including inquiries into matters concerning the competency and efficiency in departmental or public administration, as well as matters as those concerning the proper, effective implementation of policy, to make findings accordingly. Also, in the case of a particular office holder, such as the chief executive of a semi-state body, who is by virtue of his appointment, whether by statute or contract, answerable to the Houses, different considerations arise. Furthermore, it is possible for the Parliamentary Committee to conduct an in-depth investigation of a large police operation and make extensive findings and recommendations of great public and legislative import without the necessity of making findings of personal culpability of individual police officers. And the House will know that it was that question of individual personal culpability in the particular case of Abbey Lara that was struck down, because effectively, if there was such a finding of individual culpability against a particular Garda, it could amount to an unlawful killing. And that's not appropriate to this House, and I don't think anybody should argue that it is. Dr. Gerard Hogan, Senior Counsel, is well known to this House, and I think on a pro bono basis advises the Constitution Committee in constitutional matters. And he's quoted in the Irish Times on December the 23rd as being of the opinion, and I quote him, that Abbey Lara, while causing difficulties, did not slam the door shut, as many believe. He highlighted the distinction where the Supreme Court held that it was unconstitutional for the committee to make a finding that a named person committed an act of homicide, and an inquiry, for example, say into the banking crisis. His piece in the Irish Times, or that piece in the Irish Times says, and I quote it, Hogan says an inquiry into the banking system could comfortably operate, provided it was not making findings that somebody engaged in nefarious criminal conduct, unquote. I've taken some trouble to refer to these judgments because of noises coming from government. The usual ploy by government when it cannot credibly oppose a private member's bill is to allow it into committee and then bury it. That's what government successfully did before the 2002 general election with my whistleblowers bill. It couldn't risk being seen to oppose it, but they could and did kill it off in committee. Independent banking experts have since gone on the public record to say that if there had been protection for whistleblowers, the practices in our banks might never have been allowed to reach the point where the banks threatened our entire economy. But of course, government knew best. The second ploy used to demonstrate that government is the repository of all wisdom is for the minister to deride the private member's bill and to promise that he will bring forward his own bill. This happens in this House every month of the year. For example, when I introduced the Garda Surveillance Bill, the minister memorably dismissed it because he said, and I quote him, it would alert the criminal fraternity to Garda investigative techniques. Of course, a year later, a similar Garda Surveillance Bill was brought forward by the minister. The purpose was to demonstrate not just the minister's determination to fight crime, but the originality of his legislative impulse. The third ploy used by government to stymie the opposition's legislative efforts is to take refuge behind the advisorial skirts of the Attorney General. Successive Attorneys General have regaled many a dinner table as the port is being passed around, with stories of how their supposed advices are used by ministers to deride opposition legislative initiatives. In the case of this particular inquiry bill, I sought to anticipate such an argument, and I have taken care to get the advice of constitutional experts. I have frankly been told that there is a degree of confusion among academic lawyers as to where exactly you might find the beginning and end of the implications of the Abbey Lara judgment. But the same expert advice assures me that in their opinion, this bill brings inquiry by parliamentary committee into compliance with Abbey Lara. The only way to proceed, I'm advised, is to advance a curative piece of legislation designed to remedy the defect identified by the Supreme Court. If our legislation works, then governance in this state will be the better for it. If it does not work, then we have no choice but to consider alternatives by way of constitutional referendum. According to my advice, once this bill is in place, a constitutional referendum will not be necessary. But there can be little doubt about the outcome of such a referendum if it were necessary. The order made by the court in Abbey Lara was, and I quote the relevant section of it, that the conducting by the Joint Oireachtas Subcommittee of an inquiry into the fatal shooting at Abbey Lara on the 20th day of April 2000 was capable of leading to adverse findings of fact and conclusions, including a finding of lawful killing, as to the personal culpability of an individual not a member of the Oireachtas, so as to impugn his or her good name, is ultra vires, in that the holding of such an inquiry is not within the inherent powers of the Houses of the Oireachtas. End of quote. There are therefore, Last Concordia, 2 points that require to be made. Making an adverse finding equivalent to finding a specified person guilty of unlawful killing is not a matter for members of the Dáil. On mature reflection, I suspect that even the surviving members of that subcommittee would accept that investigating shootings, lawful or unlawful, is not our business. Secondly, the order of the court is clear that the holding of such an inquiry is not within the inherent powers of the Houses of the Oireachtas. This is a reference to the fact that Dáil Éireann has never conferred on itself the power to inquire into matters of public concern. The Labour Party has studied and taken advice on the Abbey Lara judgments. We have done so in the absence of any concerted effort on the part of the government to do so since 2002. The first issue, therefore, that we deal with in our bill is the question of legal authority on the part of the Houses of the Oireachtas, through their committees, to conduct inquiries. Although these Houses enacted in 1997 the Committees of the Houses of Oireachtas Compellability, Privileges and Immunities of Witnesses Act 1997, it wrongly assumed that conferring on committees the power to compel witnesses to attend for the purposes of an Oireachtas inquiry of necessity conferred the prior power to conduct an inquiry. Now the courts have held otherwise, and we must address that defect, and that is what this bill purports to do. Both of these defects have been apparent since the Abbey Lara judgment, but the government has been satisfied not to address either of them in the 8 years since then. An Oireachtas stripped of powers suits government, but it doesn't suit the people. Both houses, but especially the Dáil, are expected to investigate, appraise and criticise the actions of government, as well as to propose alterations. In other words, up to Abbey Lara, the Dáil had assumed that it had the power to inquire, but had failed to confer that power on itself through its committees. The second issue that we deal with is the question of such an inquiry impugning the good name of any person. It's made clear in our bill that it is not, and should never be, the function of any Oireachtas inquiry to conduct any form of Star Chamber witch hunt. The bill makes plain that an Oireachtas committee must not consider, and has no power to decide or report upon, findings that could reasonably be seen to attribute civil or criminal liability to any individual. Our only interest in putting forward this bill is ensuring that the Oireachtas is adequately equipped when it comes to policy making, as opposed to taking a definitive view on the facts of a controversial issue in order to identify and name and shame any individual. We recognise that there may be times when a careful line must be drawn between an inquiry into policy as distinct from an inquiry into culpability. The first is foremost properly a function of the Oireachtas, while the latter clearly is not. The judges of the Supreme Court recognise that distinction, and within the normal rules that require the courts to presume that powers conferred on other organs of government will be exercised in an appropriate and constitutional manner, will afford a degree of space to the Houses in the exercise of functions most appropriate to themselves. In fact, the majority of the members of the Supreme Court did not exclude the possibility of an Oireachtas inquiry into the conduct of ministers, who are made responsible by the Constitution, of other entities which are made responsible by statute, contract or otherwise, or of, when appraising the performance of ministers or other principals, bringing into account the conduct of staff operating under their direction. Mrs. Justice McGuinness pointed to a number of previous parliamentary inquiries and said, I quote her, "These committees have relied on voluntary submissions and willing witnesses, but there is in fact no reason why such inquiries should not use the powers of the 1997 Compellability Act to obtain necessary evidence and information." Unquote. Mr. Justice Geoghegan added, an Oireachtas committee may necessarily have to probe into management structures, and there may be, consequentially, be read into the report implied criticism of persons in existing management roles. The present Chief Justice, Mr. Justice Murphy, said, "I did not see any reason why the Oireachtas cannot conduct inquiries into matters concerning the competency and efficiency in departmental or public administration, as well as such matters as those concerning the proper or effective implementation of policy, and make findings accordingly." In summary then, Alas Cancoria, there is a need to restore the status of Parliament vis-à-vis the Executive. A parliamentary power of inquiry is necessary and intrinsic to the proper functioning of a representative, responsible parliamentary democracy. This bill corrects the defect identified by the Supreme Court by conferring a power to inquire. By way of belt and braces, the bill provides that there should be no finding of civil or criminal liability attached to any individual. The bill enables a two-stage process whereby an appropriate expert may be retained to compile a book of evidence. Section 6 allows for the appointment of a legal assessor to guide the work of the inquiring committee. In brief, only a government hostile to the proper functioning of Parliament can credibly oppose this bill. Now, I've had no communication from Minister Manzer's department about what attitude the government is taking. There is no amendment on the order paper. I sincerely hope that Minister Manzer will recognise, in the interest of the relevance of Parliament, that this piece of legislation be nodded into committee tonight, and that thereafter it be nodded into committee with the intent on the part of government to see it work its way through the House. We have been avoiding the issue for 8 years, and only in times of tumult, when something arises like the necessity for a bank inquiry, do we resort to this situation. And government have been saying facilely that Abbey Lara has finished inquiry by parliamentary committee. That is clearly not the case. And there are a number of academic constitutional experts who have testified to that fact. I refer to public coverage in the Irish Times in respect of Gerard Hogan, SC. There are others, and it is a necessary weapon in any parliament that we have the right to inquire into public administration and the quality of public administration. So I hope that it is the case that Minister Manser will permit this bill tonight to go into committee. I recommend the bill, Alas Cancoria, to the House.